Okay. Who is it?
Venetia Hawkins?
Alicia Hawkins. Was it one case?
Yes, sir.
Two cases.
There's two cases. One's going to be dismissed if it hadn't already.
Is this sentencing today?
Yes, sir.
Okay, because she had pleaded guilty earlier in 23-41581, injury, first degree felony, injury to a child,
I've
and
got 5182, or 1582.
23-41582.
Is the injury to a child first degree, both of them?
Okay, there's sentencing hearing on both of them?
No, sir. Just one of them is going to be dismissed. We're doing the sentencing on 1582. 41582. Sorry, 41582.
Okay, yes. Everything got put in the, taking all that out. What happened here? Okay. Yeah. Okay, I'm ready on it. 23-41582 is now called the state of Texas versus Kenesha Hawkins. That's you, correct?
Yes.
With your attorney, Mr. Reynolds, and the state's attorney. Earlier, you pleaded guilty to the first degree felony of injury to a child in this cause number 41582, causing serious bodily injury to a child 14 years of age or younger by failing to take the child to a medical treatment facility after it was apparent the child needed immediate medical intervention. And you had a duty as parent to take care of that child. A pre-sentence report has been prepared. If the parties had an opportunity to review it, are there any corrections or changes to it? State
Not from the state.
and defense. All right, then the pre-sentence report is made a part of the record for all purposes here. The agreement in this case is whatever sentence shall not exceed a cap of 40 years confinement in prison. So we are looking at, correct me if I'm wrong, no less than 5, no more than 40 years confinement in prison. Deferred or unadjudicated probation is an option or not?
I think so.
I believe it
Is
is.
regular probation an option on this as well?
I think so.
Yes, sir. There's no
Injury to a
deadly
child.
weapon. There's no deadly weapon. So.
All right, so there are 3 options here as I
It's
understand.
a 3G offense. I don't know.
Yeah, I don't think it may be under the maybe a limit since there's a decimal.
I said, what the number that's. If it's under A1, it's, you can't give straight probation. Under 42L54, subsection A10. If it's a first degree and the victim of the offense is a child, then you can't.
And that's what this alleges.
Yes, I don't believe you can give regular probation.
So it's just the 2 options are deferred or unadjudicated probation and flat time.
Yes.
Is that what everybody agreed? This is 22. 14 years of age or younger.
I don't see anything under the eligibility for deferred, but
Where were you on the,
42A102. I don't see a 24 under that subsection.
so you're stating she is eligible for deferred
Correct.
I think she is.
or unadjudicated probation, but not regular probation under 42A.054. The state and go open and close here on the argument.
Judge, I have one witness that would, like to testify. Call Frank Coffin from the Beaumont Police Department. He's present in the courtroom. Come forward.
Raise your right answer. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. She can come up here.
Put your right hand in front.
Coffin, Coffin, third.
Oh, yeah.
Detective, how are you employed?
I work for the Beaumont Police Department
And how long have you worked with them?
since August of 2002.
And were you the person who investigated this injury to a child that occurred back on September 29th of 2022?
Yes, sir.
And at that time, when the investigation started, I know that it wasn't apparent what was going on. Is that correct?
Not immediately. No, sir.
After a little while, though, did you start getting some conflicting stories from the defendant?
Yes, sir, we did. We were able to interview the defendant over approximately 16 hours, and we had received many conflicting stories.
Did you also get conflicting stories about that contradicted what she said from other witnesses?
Yes, sir, we did.
And during these stories, was there anything that caused you concern about whether or not she had actually caused the injuries to this child?
Yes, it became clear that she'd caused the injuries to this child.
Now, she did not plead to that in here. You understand that?
I do understand.
Were there several people that you talked to that aunts and other relatives that tried to get her to take the baby to the doctor?
We extensively spoke with all the family members. By the way, she has a great family. They're solid people. Her aunts and her father, some of the best people that I know, dealing with investigations, and they all urged her. They saw that this child was in severe distress and urged her to take her to the doctor.
Now, it turns out the doctors came up with, and the judges looked at the pre-sentence report, that the baby had developed sepsis. Is that correct?
Yes, sir.
And when looking at the way that the defendant was handling this, did she appear to be distraught over what was going on with her baby?
No, sir, not at all.
Did it appear to you that she was just trying to be deceptive throughout the process?
Yes, sir. She did not want to be caught as the one that had done this.
Was there something when the baby was at the hospital, even at the hospital, was there something that the mother was she showing concern at the hospital?
No, as a matter of fact, she called the doctors liars.
Was the baby on life support almost the entire time it was in the hospital?
The entire time. The doctor said that the baby wouldn't survive off of life support. And ultimately, that's what happened when they removed him.
Talking to the doctors, could this baby have been saved if it had been taken to the doctor after the injuries?
Immediately after, they said that there was a very good chance that the baby would have been saved.
Now, y'all worked diligently on this case over many, many months, didn't you?
This is the only thing we've worked on for myself and my partner, Sergeant Keene. This is the only case we worked on for about 3.5 months.
And is the reason for that because of the first of all, that this was such a young child?
Absolutely. And it was, of course, such a young child. And she tried to lay blame to so many different people to cover her tracks that we had to clear that.
So you had to go through and rule out every story that she gave. Is that correct?
Every story she gave, she tried to say, Judge, that all of her aunts had done this to this baby instead of her.
And you've seen the story she's come up with this time, right?
This late stage false fabrication that she's come up with now directly goes against the doctor's findings, our investigation, and her own previous statements that she's made to us over repeated interviews.
So was there anything that she ever said that came out to be true when you were doing this investigation?
The only thing that she said is that was truthful is after a period of time, she said that she knows that she should have brought the child to the doctor because it was in severe distress.
Anything else you want to add that you wanted the judge to know?
Just one other thing, Judge, I was hoping that with this late false narrative that she's given directly goes against what I would think to be to show that she's really sorry for this and to show, some character. But I guess I was wrong. We've never heard anything about some teenager and falling down the stairs. Nothing like that. As a matter of fact, she said that she put the baby in a crib before the baby had the medical incident, and the baby was fine. Said she drank 3 bottles of milk and was playing and cooing, where the doctor said that was impossible. The doctors at UTMB, Judge, said this was the worst case of eye damage that they'd ever seen. They said that the first doctor that looked at this didn't know what she was looking at and had to get another physician to come in to make sure that she was right of the detached retinas in the baby's eyes.
You've dealt with a lot. How does this one rank?
This is one of the worst cases I've ever seen, Judge.
Thank you. I'll pass the witness judgment.
The baby was brought to Baptist Hospital
Yes, sir.
by the mother or by EMT.
Are you talking to me?
Yes, yeah, to you.
Okay. Yes,
And the doctors there at Baptist Hospital examined the baby, didn't they?
they did.
And the doctors said that they couldn't find any sign of trauma at the Baptist Hospital.
At first, they did tell us that, but once the baby got to UTMB,
Okay, well, I'm talking about Baptist Hospital.
yes,
And they have fine doctors there at Baptist Hospital, don't they?
I can't talk about the fine doctor.
But the
The doctors missed it.
doctors missed it.
Yes, clearly.
Okay. And now my client is not a doctor. Clearly. Okay. So she missed it and the doctors at Baptist missed it, but they picked it up at UTMB. Yes.
Yes,
Okay. Pass the witness, Judge.
Detective, they didn't miss the sepsis though, did they?
they did not.
The baby was actually, the heart had stopped. Is that correct?
From the sepsis, from the violent attack that had been on this child, the sepsis caused the medical incident that occurred.
That was in the forensic pathologist looked at it and found that that's what caused the actual sepsis to occur. Is that correct? With
Yes.
their injuries, and that the fact that the doctors missed the injuries, they didn't miss the sepsis when it got.
They did not miss the sepsis.
That's what they were treating it for when it first got there. Is that right?
Yes, sir.
To save its life.
Yes, sir.
Pass the witness.
Anything else?
No further questions.
Okay.
Thanks, sir.
Thank you.
What else? You say?
Just argument, Judge.
Okay, go ahead. Yeah, and by the way, for the record, the pre-sentence report is made a part of this hearing for all purposes. And there is a there's a letter here from a Jessica Hawkins, who is writing on for her sister. That's your sister.
Yes.
And this is in the court's file that the court has read. And then Anthony Hawkins wrote something, and Mr. Hawkins is your father?
Yes, sir.
Not, he's not a stepfather, he's your
He's my father.
natural
Yes.
father. Okay. I think I got that. Okay, I think those are all the supplements to the pre-sentence report. Go ahead, State. You can go begin and end.
Judge, when you read this pre-sentence report, it's long, and it's long because there's a lot of facts to this. There was a lot that went on, and a lot of things that this defendant could have prevented. And I'm going to stick with the not taking the baby to the doctor. According to the doctors, when it got to UTMB, that there's no way this baby was fine, even just hours before the baby stopped breathing and having seizures and things. It was apparent that this baby had been sick for a while and it was seriously ill. And they did everything they could to try to save the baby, but the baby, I keep calling it baby, Jacaden, was dying, and was dying because the mother, who lied to her relatives, who said try to take her to the doctor. She told her boyfriend, or her friend or neighbor upstairs, that she had taken him to the doctor when she hadn't. We had all the doctors check, and she canceled the appointments for the baby. She did everything not to take care of this baby. And that's what a mother's supposed to do. And that's why in this particular instance, it's just a shame, because this baby was only 6 months old, 7 when I think Jacaden died, but Jacaden was only a little over 5 months old, almost 6 months old whenever this happened, and then 7 months old when the baby died. And it's sad, because Jacaden depended totally on the care that was given by his mom, and shouldn't have had anything happen to him. There's no record of anything going on specifically in the mom's life, except at that time, that weekend when that baby was injured, it was around that time that he was injured, was her birthday. And she wanted to go out and spend a couple of days for her birthday. So the defendant, went out and had a great time. When the baby became sick, baby was throwing up, having issues, and she did not take it to the doctor when she should have. And Jacaden stayed in the hospital even after the baby. Jacaden is in the hospital, and mom can do what's merciful and take Jacaden off the life support. She refused, and they had to actually take action to get the father to be able to take this child off the life support, because it had been deceased for weeks and was just laying there. While that's happening, there's a video of her out twerking at a bar one night while her baby's still on life support. And then when she gets arrested and thrown in jail, instead of showing the remorse and acting like the nice person that she is, you've seen the jail records. You've seen the comments about the disciplinaries that she's had over the last few months in jail, where she just keeps acting up. She's not a good person. She's not a person that goes in and does what she's supposed to do and follows the rules, and just takes care of business to show respect for what is going on and the gravity of the situation. It's all about her, Judge. This whole thing, every time I read this, and I've read the offense reports, I've gone through everything, I've listened to her statements over and over, and all I hear is it's all about her. Not about Jacaden, but about her. Thank goodness her other children have been taken away, and she's not going to have those. And I think that I wish we'd have taken Jacaden away, but we didn't know until it was too late. But I asked this court to give her the 40 years. I think it's a fair offer. I don't think there's anything less that could be fair in this situation.
All right, for the defense, go ahead.
She has no criminal history, Judge. And from day one, Ms. Hawkins has always, at least to me, been remorseful about what happened to Jacaden. And she she accepted responsibility for not bringing him to the doctor in time. And as a mother, she's lost her child, and she lives daily with the fact that she didn't seek medical attention, that maybe could have helped or saved his life. Also, Judge, at the time that the case happened, at the instant that she called the EMTs and brought her child to the hospital, to Baptist Hospital, the doctors, the professionals, could not find any evidence of trauma. They found evidence of sepsis. And these are trained doctors with CT scans, and they couldn't figure out what was wrong with the child. And they sent the child to UTMB, which in the end turned up severe, lingering, chronic injuries to Jacaden. Now, my point is, if the doctors can't figure out what's wrong with the child, how could Ms. Hawkins figure out what was wrong with the child? And she knew there was something wrong. And as a mother with protective instincts, she feels she let her child down. I think 40 years is severe, but she will accept responsibility. And I think the court should go to maybe the lower end of the range. And Anisha, you want to tell the judge anything?
Yes.
Okay.
The statement Detective Kaufman just made was absolutely not true. And my family is here in the court today to attest to that.
To what? To
That they did not urge me. They thought the same thing that I thought, that he was teething. We did not know that he was hurt.
he was teething?
Only thing was wrong with him that he was showing signs of was irritableness. Irritableness. That was it. He did not show signs that he had an internal injury that could cause his death. That is absolutely not true. My family has 100% supported me. They never went against me on that. Ever. They did the same thing 3 days prior to my birthday, which was September 22nd. He went with them. He went with them on my birthday was September 22nd. That was a Thursday. He went with them on September 23rd on a Friday. He was there from September 23rd to September 25th. They had him in their care. If they ever felt like he needed immediate medical attention, they would have took him themselves. They got Oragel and Tylenol because they thought the same thing that I thought. I never lied to Detective King. I did not. At the time, going through the process, I was numb too. My child is in the hospital. I don't know. That's all the shock. I'm numb. I'm not even in my body. I'm not even here. I don't think this is really my life. So yes, some details I forgot to tell him, like I left him with someone for 2 hours. But I always told him, the question he asked me was, did my children handle him? My children at the time were 5 and 2 years old. My children never handled Jacaden. The children upstairs, the teenager and the 8, 7, and 6-year-old did.
Oh, so it's somebody else's fault? Children?
No, I don't blame anybody. It's my fault for allowing them to even
Are
take
they
it out
the
of my
ones that
eyesight.
caused the injuries? The
The
children caused
the
Hold
trauma,
on, let
the
me
fault.
speak. Let me speak. She can't take down everything when two people are speaking at one
Yes,
time. I'm
sir.
going to ask you questions on this so that we can kind of have a dialogue. Are you saying someone else caused the injuries, not you?
My choice of allowing someone to
I'm
handle
asking
him.
you yes or no. Are you saying someone else caused these injuries, not you?
Physically, yes, sir.
Who?
A child.
Which child?
Children.
What child?
Upstairs neighbors, and I told them that they can go play back the video to see them taking him upstairs and then bringing him back down and telling
Did you
me
see them harm the child?
I wasn't in the house.
Did you see them harm the child?
No, sir, I wasn't in the house. They came back and told me
How
that
long
they
did they
dropped
get
him.
the child?
About 15 minutes, 20 minutes.
Okay. Keep going.
I take full responsibility for not getting my child to the hospital. I take full responsibility for making me out to be this monster. I hurt my child. I didn't care. That's a lie. That's a lie. And of course, I'm a mother. I'm losing my child. I don't want to take him off life support. I couldn't make that decision. I could not make that decision. I couldn't. I didn't want to let him go. I didn't.
So what about that?
And that's what they said. I made the selfish decision of not taking him off life support. That was the state's statement. That's not true. I just could not let my child go because I
What do
was
you mean you couldn't?
responsible.
Is that why you didn't bring the child to help, to medical?
He was hurt.
Is that what you're saying? That was why you hesitated bringing the child for medical help?
Yes, I didn't know.
Okay, I didn't understand what you were trying to say.
Didn't know. I didn't know he was hurt. I did not know.
Okay. What else?
I've been a single mother since I became a.
A lot of single mothers are out there.
I've been a single mother. I've never had an instance where any of my children have been hurt or anything like that. This happened with Jagada. And I blame myself every day for allowing the things I didn't allow with other kids. I'm not a monster. I'm not a monster. I don't hurt my kids.
Let me ask you, how old was the child when this happened?
It was 5 months old.
5 months.
Yes.
Yeah, there's some parts here in this report that say 7 months.
That's
wrong.
That's when baby died.
I think
It's 6 months.
he was in the hospital for a couple of months.
He was in the hospital for
Yeah,
a total of
I
a
call
month.
Okay, go ahead.
I'm just not a monster. And my jail behavior is me defending this because people are going along with what's been put on the news. So I'm defending this. I'm not what they're trying to make me out to be. I've never been in trouble. My kids have never been incarcerated. Like you said, I have an amazing family. I have the support. Not a problem. I'm not a problem. But I take full responsibility for the misjudgment and mistake I made by not taking the time to speak.
All right. Anything else you'd like to add?
No, sir.
Okay. Here's the percentage report, which has been presented and is part of the record, which was introduced and made it part of the record without objection. Court is going to refer to a couple of these. And what we're dealing with is medical science here. This isn't a soft science. This is a hard science, medical science. So, this states that the detectives interviewed you at the hospital where you provided information and initial where you provided no information about any recent injury or significant illness. Initial medical assessments indicated a severe blood infection, which I guess that's what you had told the authorities, that there was a blood infection or something?
No, that's what they found.
Well, they indicated a severe blood infection with no obvious external trauma, suggesting the case might be medical rather than criminal. Nevertheless, standard procedure in child death and severe injury cases, then the authorities then further researched this matter, and the detectives went to the residence where the child was living. And this states that the bassinet's padding was heavily soaked with liquid far exceeding what would be expected from a single infant's urination. And a preliminary forensic assessment was made over the following days at John Seeley Children's Hospital, which diagnosed the child with severe abusive head trauma. Dr. Patricia Beach, pediatrician and forensic child abuse specialist there, documented bilateral widespread retinal hemorrhages in all layers of the child's eyes with bilateral retinal detachment, and subdural brain hemorrhages, intracranial hemorrhage with traumatic encephalopathy and very significant injuries overall to the child. The doctor noted that the symptoms were compatible with head trauma. The child's condition deteriorated rapidly, became comatose, was placed on child support, and because of the diagnosis of severe brain injury, became clinically brain dead with no hope of recovery. and was rendered blind by the extensive eye damage. He also experienced multiple organ damage due to oxygen deprivation. This was, according to the doctor at John Seeley, the worst case of detached retina ever seen, along with more than one area of bleeding on the brain. The doctor later explained to investigators that Jakaden suffered severe sepsis caused by intestinal bacteria leakage, which stemmed from brain injury that impaired the organ to function properly. She demonstrated that the injuries resulted from violent shaking, which lasted 60 to 90 seconds and placed the most severe recent traumatic event between September 20th and the 22nd, which was just a few days before the child's death. Dr. Beach confirmed that the CPR performed by the officers could not have caused any of the injuries and suggested that early medical intervention could have improved the outcome. A skeletal survey performed later revealed numerous fractures to various stages of healing. These are old injuries of healing across multiple ribs, arms, legs of the child, indicating repeated episodes of extremely violent shaking over time. Dr. Beach concluded that the constellation of injuries, severe brain hemorrhages, retinal hemorrhages, eye detachments, and multiple fractures of the child's body was highly indicative of abusive head trauma inflicted on more than one occasion between the months of August and September. The Galveston County Medical Examiner, Dr. Barnhart, reviewed the autopsy findings and similarly determined that the injuries were consistent with abusive trauma. On October 30th, a few days later of 2022, the child was removed from life support. And the child died.
Judge, there's one real important on page 2. That third paragraph, which starts off with however, in that sentence, about the second sentence down. Each aunt provided consistent accounts of the child's symptoms, including green vomiting, fussiness, fever, labored breathing, which they repeatedly urged Hawkins to address medically. Hawkins repeatedly minimized or denied these symptoms and claimed that she had sought medical care. Statements later disproven by phone records, text messages, medical office confirmations, and witness accounts.
That is included in paragraph 3 of the second full paragraph in page 2 of the pre-sentence report. So three of the defendant's aunts who cared for the child each provided consistent accounts of the child's symptoms. They repeatedly urged the defendant to address them medically, and the defendant repeatedly minimized or denied these symptoms and claimed that she had indeed sought medical care, which was a statement later disproven by phone records, text message, and medical office confirmations, as well as other witness accounts. Picking back up, the defendant's behavior on the evening before Jakaden was removed from life support and died was captured in a short video obtained by the investigators. The video showed the defendant dancing at a nightclub. When confronted with the footage during an interview, she confirmed it was her who was dancing and responded that, "What's your point?" When informed that the video was taken on the night immediately preceding the planned removal of her critically ill ill infant son from life support. The investigator states that such behavior stands in stark contrast to the image of a grieving mother that she had otherwise presented to investigators and medical staff. And it certainly contradicts the way you're talking about what happened to me. That was true. You were dancing the night away but before the child is clinically rendered dead.
I do not think that was the night before he was taken off.
I'm sorry. That's what they say.
I don't remember. It was.
You don't now. You don't recall.
I'm saying I don't remember when it happened.
I think things like that would be probably blazed into your memory, wouldn't it? I mean, isn't this important?
Judge.
Oh. So the pre-sentence report from the probation office states in summary that the incident reports document a lengthy and consistent pattern of disruptive, aggressive, and non-compliant behavior by the defendant throughout her incarceration from February 23 to May of 26 at the Jefferson County Correctional Facility. The defendant repeatedly refuses to follow oral and written directives, argues with staff, creates excessive noise, openly disregards institutional rules. Her conduct frequently escalates into verbal confrontations with both the officers and other inmates, and on many interactions include hostile, profane language and personal insults directed to the staff. The reports describe multiple instances in which you instigated or actively participated in physical altercations. These include fights involving the throwing of objects, striking other inmates with closed fists, stomping, or attempting to advance toward others despite officers' attempts to restrain you, and in several instances, spitting on other inmates. Several fights required staff intervention through physical restraint, spray deployment, and on one occasion, the use of a taser when all other measures failed for you to gain compliance with the rules. You are also frequently involved in group disturbances, either as an instigator or an active participant, contributing to heightened tensions and unsafe conditions within the dorms and recreation yards at the jail. In addition to aggression, you regularly violate procedures and security rules, including entering unauthorized areas, refusing to rack up, go to bed during required times, returning to the dorm without permission, engaging in unauthorized communication with inmates in other areas, and failing to wear your uniform properly. There were repeated disciplinary actions for possessing or creating contraband, such as extra bedding, hidden razor, tattooing implements, ink containers, and a self-inflicted piercing. Reports also note instances of hygiene violations, unauthorized use of equipment, and attempts to evade or undermine officer authority by influencing other inmates or encouraging noncompliance among the dorm population. Many officers report that your behavior often disrupts institutional operations, including medical pass, chow, head counts, and normal dorm functioning. Your conduct is repeatedly described as inciting other inmates, creating hostile or unsafe environments, and contributing to escalating conflicts. And several reports portray you as openly dismissive with consequences and frequently stating that you did not care about receiving write-ups or restrictions. In later reports, officers have expressed concern that you demonstrate no sign of rehabilitation, continued endangerment to others, and attempting to intimidate the staff and some other officers, describing your behavior as hateful, threatening, or intentionally defiant. All right, well, those all going to get you gold stars. Anything to add by any of the parties?
Yeah.
Anything, Ms. Hawkins, you would like to add? You get to speak last. If nothing further, the court is going to follow this agreement of a cap of 40 years confinement. So within that, we are looking at no less than no more than 40 years confinement in prison. And how did we ever decide on the deferred or unadjudicated probation?
I believe she's eligible.
She's
Eligible for that, but regular probation is not an eligibility.
Correct.
Okay. The defendant has pleaded guilty voluntarily to this first degree felony of injury to a child by causing serious bodily injury to Jacaden Shaw, a child 14 years of age or younger. And actually, we now know that the child was 5 months here on this earth at the time of the child's death. And the defendant is accused also in this indictment that she pleaded guilty to of failing to take the child to a medical treatment facility or to a medical professional after it was obviously apparent that the child required immediate medical intervention. And what's more, under law, the defendant had a statutory and legal duty to act responsibly and timely as the defendant was a parent of the child. And this states that is a crime of first degree felony injury to a child against the peace and dignity of the state, signed by the foreperson of the grand jury. And there was sufficient evidence supporting the defendant's guilt from State's Exhibit 1 admitted at the hearing where the defendant pleaded guilty voluntarily, knowingly, intelligently, and with legal advice and legal assistance. There was enough evidence presented to support the defendant's plea of guilty to find the defendant guilty of this first degree felony of injury to this child of 5 months of age. This court now finds the defendant guilty beyond a reasonable doubt of this first degree felony injury to a child. The court is following this agreement of whatever sentence shall not exceed 40 years in prison. And this court, who has 2 children, 3 grandchildren, knows intimately that children are 2 things: gifts from our Creator, number 1. Number 2, that as infants, they are helpless to take care of themselves. And that's why we have not only a legal duty, but a spiritual duty to take care of children, especially children as young as 5 months of age. This court has read into the record innumerable circumstances where you have absolutely failed and neglected your responsibility given by our Creator and our law. I now find you guilty beyond a reasonable doubt, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years confinement. The death of a child, what is the cost? What is the right punishment? A child's loss is maybe the greatest loss that humans deal with on this planet. And I can't say enough about the special treatment that must be given to children from our Creator. And you totally failed, and not only failed, but attempted to blame others for your irresponsibility. I just wish we could have somehow, before this happened, convinced you of the importance and the responsibility that you had to your child and how that was vital to the child's existence. This is the order of the court, and we are in recess on this case. We now recall cause number 23 CR 203 the state of Texas versus Asia Kiani Young, who is present with her attorney, Mr. Turk, and the state's attorney, Mr. Hamp, are present. Earlier, the defendant pleaded guilty to injury to a child with intent to cause serious bodily injury. This is a first-degree felony under our law. That was what she was indicted for. She later pleaded guilty to a lesser included third-degree felony of injury to a child. Is that what it was?
Well, Judge, we actually, in prior proceedings, the indictment was amended on the record to reflect a third-degree felony.
Okay. In lieu of causing serious bodily injury, as it was earlier indicted, the defendant pleaded guilty to intentionally and knowingly by omission causing bodily injury and mental deficiency to the child 14 years of age or younger.
Correct, Your Honor.
That's 22.04, subpart A, subpart 3 of the Texas Penal Code. A person commits an offense if the person causes bodily injury to a child and an offense is a felony of the third degree when the conduct is committed intentionally or knowingly. Everybody agrees it's section 22.04, subpart A, subpart F. Now look at.
Yes, sir. That is the proper punishment.
And the agreement here under this third degree felony is whatever sentence shall not exceed a cap of 8 years confinement in prison. So we're looking at no less than 2 nor more than 8 years confinement. Deferred or unadjudicated probation is an option. And I think regular probation is also an option as well. 3 different options are available. Have the court had have the parties had an opportunity to review the pre-sentence report that has been prepared by the probation office, and are there any corrections or changes to it, State?
State has, and we have no objections or changes, Judge.
Defense has read it, and we have no changes, Judge.
All right. Statement open and close. And also, did y'all have a chance to read? There were some letters that have been sent and to the court. 1, 2, 3, 3 of them.
How about them up?
Or looks like from our family members because they were like they were typed on the same
They were emails to me, Judge.
same device. Then you've got 2 other letters that have been submitted to the court on behalf of the defendant. All right.
So I am going to open and close on this one, Judge. Just in fairness to Mr. Turk, I want the record to be clear that what I'm asking for is the 8-year cap on this. I feel like leniency and all that was addressed when a prior prosecutor adjusted this lady's charge down from a first degree to the third degree. I want to point out before the court moves into listening to other comments that the co-defendant on this matter received 35 years. And that was a negotiated settlement at the time of trial docket when the exposure could have been higher. I mean, it was obviously a first degree felony, but that sentence is just and proper and addresses the actual serious bodily injury that was done to this child. So with those comments, I'll wait to make the rest of my argument in response, Judge.
Okay. Mr.
Judge,
Turk.
what Mr. Dylan Banks Sr. did to the child, he was the one that actually committed the injuries to the child when Mrs. Young was not present. No one, and to include Mrs. Young, is trying to justify her delay in seeking medical care or excuse her delay in doing so. She has been remorseful. She has pled guilty. She is taking ownership of this. She voluntarily, if I understand correctly, spoke with the police and admitted that she apologized for what she did. She said what she did was wrong, but she was not the one that physically injured the child. She's the mother. She did delay in getting medical attention, as she's pled guilty to, but she did eventually the child eventually got medical care.
How?
At Children's, I think they
Texas Children.
Texas Children.
How did the
I
child
think
get it?
you called him, and
Yeah.
When?
probably several days later.
First of all, what's the status of the other defendant?
He received 35 years.
And for the court's edification, Mrs. Young and Mr. Banks Sr., their parental rights have been terminated.
Mm-hmm.
And my understanding is a child, from what I saw on the PSI, the child has been adopted. Mrs. Young does have 3 other daughters, 2 of which have submitted letters to the court along with her ex-husband. The father of those 2 daughters, all in support of Mrs. Young finding leniency from the court. There's 2 other letters from Ms. Martin and Mrs. I apologize. Warren, sorry about that. And support hers, kind of detailing her, Mrs. Young's past, where she's had abusive relationships. She's had bouts of homelessness. Her parents had issues with mental health and whatnot. She's had a tough life, Judge, and she's tried to manage. And then the other letters say that she has been a caring mother. They haven't had any issues such as this. My understanding is that Mr. Banks Sr. was an evil person, to put it lightly. He manipulated the family and did things that were just evil. And that's not to excuse what Miss Young did. She's not here. She's just simply asking the court to take into consideration that she has no criminal history. This is not who she is, but she's willing to take ownership of it, and whatever remedy the court finds appropriate. She's willing to take parenting classes. She has had a history of cognitive issues in the past. She does understand what's going on here, but she would ask the court to grant her probation, deferred preferably, so that way she can get back to parenting, taking parenting courses to improve her parenting skills, and improving her relationship with her family. And that since we have a history in the court looking at people's past for harsher sentences, I think we should take a look at her history for the fact that she doesn't have that baggage that some people that come through this court do. She has not been a problem in the court, as had been demonstrated by several other cases of recent note. But she is indeed remorseful of what happened. But she wants to move forward, if possible, with her life, but understanding that what she did was wrong.
I don't know.
All right. Anything else?
No, Judge.
Did you want to say anything, man?
No, sir.
Okay. Go ahead. Stay.
Yeah.
All right, so clearly, we're only going to hold this lady responsible for her conduct. And as the indictment is here, it's all about her omission. She admits to police officers that She knew that the child had been injured and didn't act. Every minute that goes by impacts someone who's suffers serious bodily injury. And this situation was no less than 2 days, but could have been up to a week before the incident. So to label the other co-defendant as a monster and was responsible doesn't necessarily accept the responsibility for the parent of the child who has the responsibility to do more than what she did. She did nothing whenever she knew that her 5-month-old child was suffering. That conduct in and of itself warrants prison time and does not warrant probation. One thing of note in reading her family support, which I'm glad she's got family support. It's a good thing. The court notes that often we stand in here and we don't see that. What I note in reading all of these letters is not one word is mentioned of Dylan Banks Jr. That's the name of the child that is the victim of this. Nobody offers sympathy. Nobody offers care. It's all about her. And to some degree, you can understand it when it's the individual. But the bottom line is she's responsible by her lack of conduct for the resulting injuries that this child has. The grace given to her, the lenience given to her was to say it wasn't serious bodily injury, and it clearly was. That changed her dynamics. It dealt with the fact that she has no criminal history. And although the state wasn't aware of her history, nothing in that history about what's happened to her warrants this. It doesn't minimize it. It doesn't help explain it. In fact, if anything, the fact that she had bad treatment as a child should have made her more on edge to where she would do the right thing for this child, which she did not. And I probably will be repetitive about the fact that Dylan Banks Jr. is not mentioned by anybody, and he is the victim in this. When I read through this report, I agree with, and I probably should have led off with the fact that the officer, when they get down to this recommendation, says that the seriousness of this offense warrants a significant consequence. That's as close as I've ever seen in my 36 years of practicing law, a probation officer saying that they need to go to prison. Often what we'll hear from the other side of this bench is because they write the potential terms of supervision that they're recommending probation. They're not. They're just telling Your Honor what should be done if we get there. Another glaring fact that does not help Ms. Young at all is when we look at page 2 under her family structure, she suggests to the interviewing PSI officer that she's got living arrangements. So being a good officer, that person goes and checks. That individual has not been talked to at all, is not one of the supporting letters, is not somebody that said, hey, yeah, I'm ready for her to come live at my house. I started out saying, and I'll end with saying, what happened to Dylan Banks Jr. warrants a prison sentence, and in my suggestion, it should be a term of 8 years.
All right. Anything to add? By anybody? No. No. Okay. The court is making some changes that need to be made in the documentation in the pre-sentence report. The indictment is before the court from the pre-sentence report with the pre-sentence report, but it does not have the corrections where the indictment was corrected from a first degree felony to a third degree felony. And also deleting serious bodily injury versus bodily injury. And all of that is for technical corrections in this report. Because the defendant was initially indicted for a first degree felony, it was later reduced to reflect a third degree felony of injury to a child rather than serious injury to a child. And that the change of intention to intentionally and knowingly in the culpable mental states to cause bodily injury and mental deficiency versus serious bodily injury or serious mental deficiency were corrected and amended by the agreement of the parties, which changed this punishment range from a first degree felony to a third degree felony. This is why, and then the resulting agreement of a cap of 8 years. What is brutally honest about the facts of this case is that a 5-month-old infant, the defendant's child, on January 20th of 2023, and this is now 3.5 years ago, was brought to Texas Children's Hospital in Houston by the defendant and Dylan Banks Sr., who were the parents. And the evaluations from the Children's Hospital revealed that the child had suffered serious injuries indicative of abusive trauma, which included multiple rib fractures, brain bleeding, brain tissue damage, bilateral retinal hemorrhaging, bruise to the neck, potential spine injuries, and was suffering from seizures. This was deemed critical injuries. The child was placed on a ventilator shortly after the admission, and then Child Protective Services and the Houston Police Department were alerted. And during the investigation, Banks' father admitted to shaking the child on January 13th, which would have been a full week before the child was brought to the hospital for care. And when this defendant was interrogated by and questioned by authorities, the defendant acknowledged her awareness of the abuse inflicted by the father, and that he had texted her around January 18th, which was 2 days before the child was brought to the hospital, claiming that the child had stopped breathing, but he had revived him. And despite learning of signs of distress and bruising on the child, Asia Young, this defendant, did not seek immediate medical help or report the abuse, and claimed that she did that because she was in fear of the injuries being discovered by the authorities on the child. And consequently, it was determined by the investigators that the defendant had intentionally or knowingly caused serious bodily injury to the child through her inactions and failing to fulfill her legal obligation to provide necessary medical care. But that charge was later reduced by agreement by the parties to bodily injury rather than serious bodily injury. According to the recommendations from the probation office in the preparation of the pre-sentence report, it was summarized that given the nature and circumstances of the offense, the significant harm suffered by the victim, and the defendant's failure to take appropriate action despite having a duty to protect the child and obtain medical care for the child, the officer believed that the seriousness of the offense warrants a significant consequence. And truly, who wouldn't? This, once again, I'm like deja vu all over again with an infant child barely out of the womb, 5 months old infant, suffering severe injuries, and then the people who were responsible or knew about it and were responsible for action hesitated and delayed. And thus, by failing to act, caused more of a dangerous predicament to the child, who in 5 months is literally helpless to take care of itself, but must rely on our creator and our nature, and the nature that allows the parents, the responsible parties to the birth of the child, to assume the responsibility of proper care, which was not done in this case. I don't believe anybody contends that this defendant had anything to do with actually directly harming the child. Isn't that right? I don't see anything in those 4 quarters. But days went by before the child was brought to help. And that is a parent's responsibility, in spite of the other parent being viciously responsible. And that's what resulted in his 35-year sentence. Now we're dealing with someone who may not have had direct contact with the harm of the child, in the harming of the child, but yet had a natural and creator-given responsibility and a lawful responsibility to seek emergency care as soon as possible. And that delay put this child into harm's way, greater harm's way, by continuing to suffer those serious bodily injuries. I mean, a child can't go along with brain bleeding and multiple rib fractures and brain tissue damage and retinal hemorrhaging. And those are going to ultimately probably result in long-term disabilities for the child during its life. So that's where we are on that. Anyone add anything? State,
No, Judge.
defense,
You've summed it up.
Okay.
ma'am, you want to say anything else? If nothing further, I'm going to find that Asia Young, the defendant in this case, has pleaded guilty to the third-degree felony of injury to a child. Voluntarily, you have pleaded voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at this guilty plea hearing, which admitted responsibility under the law to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of injury to a child. And I'm following this agreement. You were hereby sentenced to confinement in the institution of division of the Texas Department of Criminal Justice to serve a term of 8 years confinement. A parent has a very special obligation. This is a duty. And you delayed knowing that the child was injured. And the child is lucky that the child did not pass away, but we can all use reasonable thought here under these injuries that the child may very well suffer long-term, if not lifelong, harm from the delay that was caused because the responsible parties did not either act correctly at the beginning or did not seek medical care when the parent was aware that the child needed help immediately. Child is helpless with their 5 months old. That's why the parent's duties are strict under the law, and the law provides serious penalties when the parents do not act responsibly. This court finds that under these circumstances, the sentence is fair and appropriate, and also sends the message that a 5-month-old, all children's lives are not only important, but are dependent upon, and their well-being are dependent upon the parents, the caregivers' responsibilities to deal with any problems immediately and responsibly. And this child was not dealt with properly, as a parent should deal with child's injuries. Thus, this court finds this to be a just sentence under these circumstances. Anything else?
Okay.
That is all. We are in recess on this case. All right, we're going to be going into voir dire here in a moment, and we'll be done while we pick a jury. Thank you.